Hello, everybody. Welcome. Welcome to the Space's latest webinar in our ongoing series, where today we're going to be discussing digital rights. And this is sort of a sort of loose part two, I suppose you could say. We have come back again today following our rights webinar in June, which was hugely successful and which had an unprecedented number of questions from those of you who attended. So we've decided to regroup again today with the same panel and to try and make this section focus less on presentations and more on addressing any questions that you might have. I should say, for those of you who weren't able to join us in June, the recording of that webinar is up on our YouTube channel, so you can go and have a look at that material there if you want to. But as for today, as I can see my colleagues are saying here in the chat, we're going to be using that chat function. So do select it from the menu, I think along the bottom for those of you on desktop, and I think in the drop down for those of you on devices. We're going to be using that chat, so do take a moment to introduce yourself and say hello. We'll be using that for your questions as well, so do pop your questions in there. And for those of you who would like captions on, we have a live captioner with us today, Jen Cinnamon. Huge thanks to Jen. We really appreciate you being here. And you can turn those on by pressing the CC Live Transcript button at the bottom of your screen and selecting Show Subtitle. Again, there's information on that in the chat there too. But as I say, we're going to be discussing rights today. We'll be here for 90 minutes. We're here till 12:30, and we will have a screen break halfway through as well for everyone to blink and look a bit further away. And get yourself a cup of tea and so forth. We have a panel of three fantastic speakers that you may have seen before, and I'll introduce those in a moment. I'm confident that as a group we'll be able to help you with whatever aspect of digital rights you're finding to be challenging or you're finding to be new territory for you. As stated on the event page for this webinar, we should say please be aware that explanations and suggestions given during this webinar cannot be used as legal direction. You may still need a legal opinion to make your final decisions. However, over the course of today, we'll hopefully demystify that process for you, break it down and set you on the right path. As I said before, we will be using the chat for your questions, and do start getting those in as early as you want to. I will say from our experiences last time, I can recommend to get your questions in early, as if you wait till the end, you may find that we run out of time before we get to you. And I should stress, please don't worry about asking a question that someone's already sent in or a question that you feel someone's going to talk about anyway. It's always really useful to us to see if a topic is of interest to more than one person. And I myself will be moderating as we go to group questions together wherever there's overlap. So please do pop them in. You'll see that what we talk about today will fall broadly into two categories. It's worth flagging these up front, just in case you find that the conversation starts in a direction that doesn't tackle what it is that you're exploring. Those two categories, the first one is going to be securing third-party material, such as music, video footage, lyrics, and so forth. And the second area that we'll be looking at is ensuring that you yourself are entering into the right agreements with your own team, your own staff, your own collaborators, at the point at which you create something new, or the point at which you want to further make use of something that you've already made together. You'll see as well that our discussions will approach these challenges from different fronts. We'll discuss some of the aspects that you'll need to cover within your agreements, ensuring that you're being specific and transparent and fair. And we'll discuss how and when you might want to have those conversations with rights holders, as we recognize that it can sometimes feel intimidating or a kind of over formal aspect of what until then has been a wonderfully creative, collaborative relationship that you've had with them. And we recognize that sometimes that can feel a bit awkward. And we will also be discussing, I suppose, contingency options for the times when you've simply been unable to secure permission to use, for example, a snippet of pop music in your online video, or you've been unable to track down the rights holder for a piece of archive or a piece of vintage material. But we'll start first of all with introductions to each speaker. I've selected some of the questions that some of you have sent in advance in order to demonstrate to you their backgrounds and expertise. But as I say, please do start using that chat and getting those questions in, as we'll jump straight into those afterwards. First of all, we're going to come first of all to the first member of our panel, who's Jamie Smith. Jamie, if I could actually come to you first, if that's okay, as I thought it might be worth introducing some of the kind of broad terminology that we might use today. Someone has asked the question about what clauses should they be including in contracts for creatives when streaming filmed theatre productions. And I think it is worth acknowledging here kind of what are the variables that I know we talked about last time. And at the same time, I might add to that a question about, I suppose, the difference between if you're seeking permissions or a license or a buyout agreement, the different nature of what those agreements or documents might be, because I know they might go from being incredibly formal and intimidating to something that maybe people might feel more comfortable with. Is that all right if I pass the mic to you to just introduce yourself and give us your thoughts on that?
Sure, thanks. Morning, everyone. For those who don't know me, my name is Jamie Smith. I'm a partner at Sheridan's. We're a media firm based in London, but with clients globally. My particular area of practice focuses on those in the media sector, in the content creative side of things. So those companies, clients who are working in the animation sector, live action, television commercials, games, AR, VR, and so on. And really, I guess, just that sort of sense of the cross section, especially as you're moving into some new technology, using technology platforms to deliver new theatrical content, whether that's sort of new apps on your phone or whether it's sort of streaming productions, etc. And we work with a range of clients across all of these areas, covering clearing content, looking at questions around IP, and that's fundamental. Just to give you that sort of context, that these questions that we sort of go through today, points, these are always day-to-day questions. They come up with every client, from small to large. What can we do? What can we look at here? And I guess I'll start with, I know there's a couple of questions that have just been raised, but I guess it's back to this point of principle I discussed in the last seminar. Really, the point around content is to be fundamentally clear on who's contributed what. So in the sense of, if you are a company, you have perhaps a mixture of employees, freelancers, and then you're licensing or looking to get content from other third parties, whether that's a image library or you want to use some footage that someone's filmed. There's effectively a combination of rights coming in to make the final film or the final dramatic piece. And really, the key takeaway, I guess, from this talk and the seminar in particular is just track who's contributed what. That is fundamental, and it's always a piece of advice I give to anyone creating content. Just have a document tracker. Who's inputted what? Who are they? Are they an employee, or are they a contractor, or is it something from the net that you're looking to license? And the reason for that is very important, because there's different rights that it could attach, but there's also different ways of contracting for that content. So I'll sort of come on to that in a little bit more detail perhaps further on, but the point of that document is it gives you a nice overview as to who's contributed what, where are the rights, and what have you licensed. And it could be right down to the smallest things. So we had a query the other day of someone shooting a piece of film in a public park. There was some graffiti and some artwork in the background, and it's a question of, well, can we include that? And again, just to give you an example, there isn't necessarily a straightforward answer to that, and it's this whole point that rights can exist in all types of content that's coming together. But the basic rule of thumb is understanding the rights. But if you are a company using employees, majority of employment contracts positions, the IP will transfer to the company as their standard form of employment. So if you're working with employees, you can be fairly comfortable that what they're working on, you'll obtain the rights. Very different with third parties. If you're engaging a third party, and this is perhaps one of the sort of misunderstood aspects of a lot of the advice we give, if you're engaging a third party, a contractor, a freelancer, a creative artist, or a software coder, the fact that you're paying them, especially in the UK, the fact that you're paying them doesn't necessarily mean that you automatically obtain all of the rights and ownership for that work. And that's an important distinction, because what happens is a scenario whereby you may say to a creative, right, we want you to do some concept work, or we want you to do some design, do some background designs for us for this piece of creative content, and we'll pay you X. They deliver, you pay them. There's no contract in place. There's nothing else stated. It's simply, we'll pay you to deliver this work. You say, great, the work's great, you use it. And perhaps you're using it for a theatrical production. Now, if you then want to move away from what you were originally creating that for, and perhaps you want to now put it on an online platform, you want to stream it, you want to turn it into and use it as a segment in a movie, you don't necessarily have the rights from that creative to do that. And that's a really important point, is that unless you're very clear as to what rights you're looking for, the basic position would be that you're getting the rights to use the content for the initial sort of envisaged piece of work. And so again, if you're then looking to exploit that further beyond just that sort of creative piece of creative work, there is a potential that someone who you paid could still come to you and say, well, I didn't actually give you a license to use that content for additional purposes. And so from a position of where you think, well, we've paid really good money to have all of this content created for us, you're actually on the back foot. And that's why it's really important to gain that understanding of what rights can come in, and where do they sit, and who owns what, and basically what are you looking to obtain. And so I guess that comes on to sort of contracts. What should you have in place? And this is always the sort of scary point. Detailed contracts. There's contracts out there which are super sort of detailed, go overboard with what they're explaining. The basic position is, I guess, twofold here. One, do you want to have a buyout of the work, or do you want to have and happy to have a license? In terms of terminology, a buyout simply means, as it sounds, you are paying someone to create a piece of artwork or other content, and you're buying out all of the rights in that. So effectively what you're saying to someone is, I'll pay you £1,000 to deliver this, you deliver it, and I have all of the rights then to do everything I want to going forward. I don't need to come to you for any further licenses. I don't need to pay you anything else. I'm effectively, this sum of money is in full consideration for all of the rights that I want going forward. Now that's the sort of the cleanest, simplest way of getting content. You can be assured that going forward, unless they've copied the content from someone else, that's a different sort of position, but you can be assured that you've got all of the rights you need to use that content. The other situation is if you have a license, and this may arise, and people say, well, surely we always go for a buyout. That's the simplest way. Well, ideally, yes. However, things like budgetary constraints, so you may have a limited budget. You may say to an artist, for example, I keep picking on artists, but it can equally apply to other content creators with certain exceptions, which Alex will come on to in music, for example. But you can have a license. You may say, well, we don't have, the artist may say, that's great, I'm happy to create this content for you, but I can only license it to you for that particular show. If you're doing a theatrical performance, for example, and you're using it as a backdrop, or you're creating a piece of online film content, they may say, I can only license it to you for that piece of content. Now, in that situation, this is where it's important to determine, well, what are the terms of the license? What do you need the content for? In some cases, if you're literally just producing something, a one-off show, it's going to be broadcast once, you're never going to repeat that again, you don't need it for anything else, then you would just license the content for that and be reasonably assured, right, we've got the rights. But if you're thinking, well, actually, we might need it for longer, then suddenly you get into different permutations of a license. You could split the license up into a number of years, for example. You say, well, we'd like to license content for a year or 2 years, or we'd like to know the fee if we want to buy it out. So you can have a situation where you licensed content for a certain period, but you can actually have an option to buy out. Where can we use it? Can we just stream this in the UK? I mean, streaming just in the UK is probably a very, very dangerous position, because the whole nature of streaming services in a way are to be on a global scale. So again, but the point I'm trying to make is you can cut this up to meet your budget, but you've just got to think carefully. And this is the strategy. What do we want to do with content? And especially if you look at how content has evolved, how content is used, we're looking at content that was created 20, 30, 40, 50 years plus ago, being reused, being sort of recut into something new, being broadcast on a different channel, being streamed for the first time. And these are points that people back then didn't really sort of contemplate. These new technologies, ways of streaming content, accessing content, were not really sort of planned for. And so again, this is where licenses become quite tricky unless you need it for just a specific one-off piece of work. So that's really the difference between buyouts and licenses. And then in terms of, I appreciate this is a little bit of a whistle-stop introduction, but in terms of accessing, in terms of the type of contract length, the simplest position to start with is at least having something in the email prior to commencement, something that you're jotting down saying, I want to pay you X. This is what I need the content for. This is what I intend doing with it. These are the terms. And at the very least, you've got a starting point. So if you don't manage to get a contract in place, not everything gets contracted. If you're going in and then contracting with someone once it's underway, at least you've got a great set of written principles that will be taken into consideration if there is any argument there about what was licensed or what was paid for. And at the very least, then moving forward with those, to then just wrap some simple legal terms around, that just gives you your commercial foundation. And that's super key, really. What is it you're contracting for? What amount are you paying? How long have you got those rights? And just keeping those simple points down puts you in a really good position. And as I say, to wrap around to the start of my introduction point, it then feeds back into your sort of IP register, as some people call it. Really, this piece of work, who's contributed towards it? Have we got the license or agreement in place? And are we clear on what we can do going forward? It can be a lot of work, and certainly we're not advocating that you do this for every piece of content you create or production, but certainly if you're investing a lot of money into something, you're creating a game, or you're creating theatrical content, or a new piece of animation, for example, having that gives you the cleanest route going forward, and you know exactly what you own, what you can license to third parties, and what you can simply do with the content. It's having that oversight, really. That's super, super key. So appreciate that was probably a little bit of a whistle-stop tour around contracts and some of the terminology. And then I think there was some questions. So I don't know how we're handling questions.
I can go through and kind of moderate the questions from the chat, and thank you to everyone who's already been putting them in. That's fantastic. I want to introduce the other two speakers before we tackle some of those, but actually that first one, I thought it was possibly worth clarifying there, because that might be quite a quick one for you, Jamie. Christine has said at the top, can buyouts also offer royalties? It sounds like you're defining a buyout as the type of agreement where you do just buy all rights and there aren't ongoing royalties, as you might do with a license or another type of agreement. Is that right, though?
Yeah, I mean, it's people, terminology gets mixed, but really I like to keep it quite simple. To me, and advice that we give, a buyout is simply that. You are effectively buying out all of the rights across any media platform, and you're paying a fee. Now, you can attract royalties to that if, for example, and that's what a lot of the streaming platforms might do. For example, is and when I say streaming platforms, I mean the broadcast platforms like Netflix or Amazon or Disney Plus, for example. They would say, right, we love this piece of content you created, whether it's a book as a piece of IP, or whether it's a play, or whether it's a short story, we'd like to buy that out to create a TV series. Now that's where the terminology starts to get a mix, because they are buying out all of the rights in that IP to own, but they would look to perhaps give you royalties on the back end as part of the fee. And that's where you've got to just be careful. The fee can be mixed. So you could have, when I say fee, paying for a buyout, they could give you a complete all-in-one payment. Here's £1,000, here's £10,000 for that content. We're then free to take it away. You have no further rights. There's nothing else you can do with that content. On the other hand, they could say, well, we want to give you this amount of money, but we're then going to also give you a royalty, a further payment when we actually sort of utilize the IP. And again, you can get quite complex with this. Take a book example. If a platform's licensing a book, they could say, well, we'll give you an initial payment of X, and then we'll pay you a certain percentage if we're broadcasting TV. If we sell merchandise, for example, from the series, we might give you another percentage. If we then create a new digital platform or a game from that, we'll then give you this percentage. And again, the point being, there isn't necessarily a standard formula to that. It really comes to perhaps the strength of the IP. Is it, for example, if you're looking to license Harry Potter now, obviously you're in a very, very different scale of content versus when it was first created. The first book was released day 2. You could perhaps get the rights to that extremely sort of cheaply and across a whole spectrum of platforms. And this is the point. There isn't a right and wrong answer. There isn't a standard contract template you can fill in a way. There is really sort of, what's the value? Have I thought about all of these different avenues that could be exploited? And that's really the difference. A buyout is you losing control almost of the IP. Look at it this way: you lose control, you might get some residual royalties. A license is you keeping control, or the creator keeping control, and giving you really a set limitation of rules. Where can I exploit this? How can I exploit it? And how long can I exploit it for? And those are really the principal rules around a sort of a license.
That's fantastic. Thank you so much, Jamie. We're going to introduce our next 2 speakers. Just before we do, I did want to pick up on, because I remember someone saying to me after the last one of these, is it possible, just before we move on, just to define what you mean by exploit? Because I know it's a word that makes a few people wince if it's not a word they've used before. It might be a word that has negative connotations attached to it. But...
yeah, I guess it can, because I mean, you can obviously use the word to exploit someone. I mean, it's sort of use the terminology. You're exploiting the terms of the license. Effectively, what rights do you have to use the content per the terms of the license? So rather than exploit in the sense of taking advantage, you're looking to utilize the content according to the boundaries of the license terms. So how can you use this? I'm working on the basis that unless it's explicit there, and there are some slight exceptions to this, but unless there's really explicit there, so simple example, you can use this piece of content for 1 year from its first public use across television platforms only in the UK. So in that sense, if you wanted in year 3, you said, oh, that was brilliant, we want to do a rerun of that, you're outside the 1 year. So if you look to use that content, then you're in breach of the license terms, you're likely to have to pay additional fees and so forth, and the same with the platform and the same with the territory as well. So it's really sort of exploit using the content in accordance with the terms of the license.
That's fantastic. That's really useful. Thank you so much, Jamie. We've got a couple of excellent questions as well. I can see one of them's already been addressed. So someone had said, is there a resource you can recommend where a small company can access a set of sensible contracts? That was from Andrea. Thank you so much. And I can see that my colleague Angela has already flagged up there is a rights toolkit on the Space website that does have a section that looks at contracts. Exactly as Jamie says, there is not going to be any kind of hard and fast rule that's going to work for everyone. It's about finding what works for you, but that will talk about some of the terminology. There's also a couple more questions people have asked, which I'm going to bring in the other speakers because I think these would be quite useful for as a roundtable discussion. Thank you so much, Jamie. We're going to move on to introducing our second second speaker as well, which is Alex Hancock. Alex, I'm going to ask you to join us. I know that your background, your area of expertise is specifically music as well, and you've worked on a lot of large projects with a lot of very famous pieces of music as well. We had a couple of questions last time that nicely illustrated the different ways in which people do use music for a project. Obviously, people were saying, how do we secure permission to use a particular piece in a dance video or a play or something like that? We've also had people asking about sync rights. We've also had people asking about sampling, little snippets and things like that. People also asking about what to do if a musician has since died. I just thought it was worth doing a very kind of broad question about all of these different ways. Just clarifying, do all of these uses need to be paid for if we're going to use third-party music? I know that might not be as simple a question as I've phrased it as.
Well, I guess they definitely should be paid for. You could get some sort of gratis contract if you were able to, say you were friends with somebody, the composer or whatever. But yeah, you would need to secure the rights in some form, and that usually be in exchange for some sort of payment, whether that's all the different things that you just mentioned and all the other possible ways you can use music across media.
Because I remember there was a myth that I used to hear a lot of, and every couple of years it rears its head again, where people saying, oh, as long as I'm using less than 6 seconds, or as long as I'm crediting it, or as long as I'm doing something like that, I can use it for free without paying. I mean, is that a myth?
Yeah, it's a total myth. I remember joking, I think maybe Jamie's law firm started that because, it's just going to, there's nothing about it. All these terms, things like fair use and things that get bandied about, then it doesn't, no, in no way whatsoever. And I guess the way I've always spoken about it is like, you can break any law and get away with it, whether it's copyright law or traffic laws or all different things. It's like, are you going to get caught, right? So people, like producers, can sample a song illegally and get away with it. And that's usually if the song's not very famous. Then,
Right.
For instance, I know the guy who had his record label, Harlem Shake, by this guy called Bauer, and it was a small song which randomly went viral maybe 10 years ago, and it was very briefly the biggest song in the world.
Yeah.
And that had an unlicensed sample in it. And normally they would have got away with it because they may have only sold, 500 copies of a record and something like that. No one would have noticed. But because it became the world's biggest song, they got in a lot of trouble because someone was like, oh, you've done that, plus we can make a lot of money off you. So it's the same sort of thing. Anyone can get away with stuff, and you might know people who have done it, but it doesn't mean that you should. I think you really shouldn't, but also doesn't mean you can.
Absolutely. And I know there have been huge stories. I mean, De La Soul's 3 Feet High and Rising, which was a huge iconic album built on lots and lots and lots of sampling, and the record label said, oh yeah, we'll do the legal stuff, just thinking they were going to press 12,000 copies and that would be the end of it. They were a small indie label and they didn't, and it meant that De La Soul lost the rights to their own music for 25 years as all the people that had done it. So yeah, you're absolutely right. It's one of those things that you can sort of try and push, but it's absolutely not absolutely not best practice, and when it goes wrong, it's really going to go wrong for you. Yeah, absolutely.
It can go very wrong. Yeah,
I should stress as well that that rumor, that 6-second rumor, is something I've been hearing for sort of 25 years since my days in student radio. It was floating around for a long time. So yeah, absolutely. Can I ask you a little bit as well, Alex, just for those that maybe didn't see you at the previous webinar? You've done a lot of work on some very large projects. I know some very recently as well that have had a lot of work that's needing to be cleared and licensed and things like that. Can I ask you just to talk a little bit about some recent projects that you've done and some of the work that's been involved in those as well?
In what form? In just how I would license the music?
Yeah, exactly. Just because I suspect there may be people here today who weren't at the previous one as well, and they just don't know about the work that you do really, and kind of what's involved with it all.
Okay, well, I guess I've worked as a music supervisor across film, TV, now computer games, film trailers for the past 16 years. And it's the same whether it's the smallest production. You may say, for instance, I'm helping a small art gallery to clear a short film for maybe 2 weeks in an art gallery in South London. And the process and securing the rights is the same there as when I've worked on a massive film with a £10 million budget. You know, you find out who owns the publishing rights, you contact the owners, you find out who owns the recording rights, you contact the owners, you negotiate a fee. It's usually most favored nations and all those sorts of things. You secure contracts and the invoices and you're done. So yeah, I guess there are differences in the process, like how tough it can be when it becomes something quite small versus something quite big, but it's always the same. It does not matter.
Yeah, that's fantastic. Thank you so much, Alex. We're going to come back to you as well, and I know there's some roundtable discussions as well, but that's fantastic. Thank you very much. We'll move on to our third speaker, who is Lottie. If I can ask you to, Lottie Gazard, if I can ask you to turn on. Hello there. Yeah, Lottie, if I could ask you just to introduce yourself as well, because I suppose you've been on the sort of production side of things for a long time. So yours may be the role that most attendees here have got the most in common with. And I know this speaks to your experiences as well. This is quite a fun question because I know you and I have talked about this before. But if I can ask you to introduce yourself and maybe talk about someone who said they're trying to use archive material. They're trying to go back into their archives, find pieces that weren't cleared for digital use, that weren't cleared for even public use, really. And they're looking to secure the rights to an existing piece of video material. I suppose we'll talk about the kind of hows of that as we go on. But crucially, this person has said, look, how can I plan to ensure that this doesn't keep happening? You know, how can I open up those early discussions with rights holders about the digital rights for third-party content at the same time as negotiating the live rights? Can I ask you just to talk about your experiences of that?
Yeah, absolutely. Thanks, Rob. Hi, everyone. So I'm Lottie. I've worked in TV production and content production for over 30 years. So I sort of always feel on these, I love doing these webinars because I've got lovely Jamie and lovely Alex, who are the people that do all the legalese, and I'm sort of there. I'm you, really. I'm the person who's been in that situation with someone saying, we just need to get this cleared, and how, you know, we've then got to work out how to do it. So I completely sympathise with any of your questions and all of your questions, because I've been there, believe me. So I've worked mainly in music and arts for the last 20 years. So a lot of events, theatre, dance, music production of all different genres and kinds, documentaries, events, and was up at 2 a.m. yesterday to cover the OB taking the Queen from Wellington Arch to Windsor yesterday, so a bit tired today. But it was it's a wonderful thing to be involved in. Luckily, no rights clearance is involved in that. But I think the thing, I mean, as you say, Rob, it's archive is one thing because it's something it's coming back to it. And Jamie made a point about, you know, those sorts of things where you're going back to something that may have exploded in popularity since it was first out, but so it's sort of a twofold question and answer, really. That the first thing I think is always just get in there as early as you possibly can. Again, Jamie touched on this, is start thinking about what you might want rights for as soon as you start thinking about your project, and also every individual contribution and what that might entail and what you might need from them. Because essentially what rights are is just paying someone for the things you need from them and their contribution, be it artistic or performance or even just vocal. So I think the main thing that I would say is do those things right at the start of your production. Make sure you ring fence some time to think about it, because the longer you leave it and the later you leave it, the more difficult it's going to be for you. These things do take time. And again, if you've seen the webinar, you know, all three of us talk about how long it takes to get clearances done. So the sooner you start, the better. And being very clear, again, as Jamie said, you know, just being very clear about what you know you want at that time. Things may change, but again, it's sort of just being very clear from the beginning about what you want your project to be, what platforms you want your project to be on, and what future exploitation. Again, I totally get the point about the word exploitation is such a negative one, but it is just how you want to use someone else's contribution. So it's the using someone else, but in a good way. And I think also it's the thing that I always say is don't be afraid of it. Don't be afraid of it. Rights are right. It's the right thing to do. And all you're doing is putting someone's contribution out there. And, you know, lots of us are ex-artists and musicians. We want our contributions to be seen. And I think if you come at it from that perspective of actually what you're doing is allowing other people to see someone else's work, it's a really good thing. It's a positive thing. And most people want that to happen. You know, they want to help you get to that point where you're allowed to show that. So there are some people who can be very limiting, but most people want you to use their material because it means they get seen as well. So be positive, come at it from a positive perspective that the person you're trying to negotiate with really wants to make this work. But again, it's just being very, very clear, not hiding things, not ignoring things, and just dealing with it at the time. So essentially, when you're first contracting contributors, you know, the rights should be something that you roll into that initial contract right from the beginning. So think of it right from the start. And then we come on to archive. So it is a minefield, and it is very difficult. And again, it is massively time consuming. So again, make sure you always leave time in your schedule to spend time, because it will take a lot of digging. Some things, it's always dependent on what paperwork is available from when it's previously been used. I mean, again, if there's, as Jamie said, keeping a chart of everything, keeping everything in writing, a really simple, easy to follow, easy to read chart of everything that you use in your production, which can be passed on to other people, is gold dust for anyone who's then trying to clear it afterwards. So it's the old country code, leave as you find. And just think about, if you were the person trying to find that thing, what sort of information would be useful for you to pass on to someone else, and write it down and keep it in a place with all the other legal paperwork for your production, so that that can be passed on as an archive for someone else to find the rights holders for it. And of course, that is the most time consuming and difficult thing. And I'm sure Jamie and Alex would back me up on this, that actually trying to find the person who holds the rights can be the thing that sometimes takes the longest time. It is a massive research project, and it is just going through the obvious. You know, if it's an artist, if they are still alive, then they'll have an agent, they'll have an estate if they have passed over. So it's just a digging process to just go through every level of which rights holders there may be. And again, keep records of it, keep notes of emails that you've sent, people that you've phoned, write everything down, so you've got a paper trail all the way through of what you've gone through, who you've been in contact with. And again, as Alex has just pointed out, it's not there. You know, if you don't have the rights to use something, you don't have the rights to use it, and it is a massive risk. And again, this 6-second rule, you know, I've been told previously, anything under a minute, it's fine. Please don't ever believe anything like that. If you don't have the rights, you don't have the rights, and it's a massive risk. And the onus is always on you to clear it, and if you don't, then you're the one who's in trouble at the end of it. So don't ever listen to anyone who says, yeah, that's fine, don't worry, just go ahead and use it, because it won't be fine. Somebody will find it. So I think with archive, again, it is really just making sure you've got time for it, but also it's weighing up, because all of us have our production schedules are tight, the budgets are tight, time is really tight. So it's always a weighing up exercise of how desperately you want to use that piece of archive, opposed to how much time it's going to take to clear it, whether you've actually got time to clear it. If you haven't, you might just need to drop it. So it's always a weighing up risk, money. If it's a very going to be a very expensive thing, you probably won't have the budget to clear it, so let it go. And there are always alternatives that you can find. They may not be exactly what you want, but I think that sometimes with clearances, just because of the time frame and the budgets that we're all working to now, a level of compromise, it's okay to do that. You can still maintain very high production values, getting alternatives in. Is that okay, Rob?
That's fantastic, thank you so much. And I know for anyone who's interested in that, we do check out that recording from the previous webinar if you weren't with us as well. We talk a lot about plan A, plan B, plan C, plan D, and so forth. Make sure that you've got alternatives, just in case you simply cannot secure the rights to that one piece of music that you've got in your mind. We'll go through some more of the questions here. I'm going to ask all three speakers to turn on mics and cameras, if that's all right, and we'll start going through these questions, and do kind of jump in if you've got something to add to any of these. The first question actually is quite an interesting one we've had here from Christine Masters, who when we're talking about buying up doing buyout agreements with people or securing the copyright from writers, they've said, what does the moral right of the author mean in terms of copyright? Can we really buy the copyright from writers? And I suppose my own instincts, and jump in if you disagree with this, you're only securing the rights that the other person is prepared to give you, first of all. You know, they're not obliged to sign over things that they don't want to. At the same time, it may be the licenses that or the permissions you're seeking from them, they may be non-exclusive, or they may be that you're only seeking digital rights where they may have analog rights, or it may be you've got them for a short amount of time. But I suppose, has that ever arisen, that kind of moral right of the author when looking at contracting? It may or may not.
I'll jump on this one. It is actually becoming more and more of a question. I mean, previously it used to be just a point that was sort of stated in the contract, and probably people didn't really sort of see realize what it meant, or as perfectly evidenced by the question. And it's a good one, because it is that type of clause that just does sometimes get in there and people don't really realize what it does. Now, it is simply, as it sort of explains, it's your moral rights in the content. And if we give, I give a good example that we sort of come across quite a bit is, say, for example, a director of a film would often be asked to waive their moral rights. Now, and that happens a lot in commercials, for example. Now, what does that mean? It's basically their sort of rights in that content, in terms of, well, it's hard to say, but it's the content being used for the purpose that it was intended for within certain boundaries. And a simple example of that is if you commissioned a film to advertise, say, a pair of jeans, but then that same film is then being used to advertise sort of an arms dealer in a certain country, and to sort of look and sort of on the basis of their weapon sales, and used to sort of as a promotional video for that. There's a moral aspect to that which the director hasn't sort of necessarily given their consent to. Now, it is a tricky area, because you say, well, where does the boundary lie? Where do we see this change? And it has to be, in our view, in my view, a real sort of a change in scope, and a complete sort of, if this was something the director knew, they would not agree to creating the content in the first place. And so in that sense, you can probably, if you don't waive moral rights, you're probably okay for the majority of content, I'd say. Again, depending on the type of content you're looking to sort of commission, and ultimately where you want to use it. And it's also important to note, in certain territories, I think France is a good example, you can't actually waive moral rights that are enshrined in law and protected in that sense. So again, there's going to be certain territories, and we've seen this not just at a director level, but people creating content, the actors in, say, an advertisement, they've been used for a particular brand, for a particular aspect, and then suddenly that's been taken and used for something else by the advertising agency. That's where the rights, people could say, actually, no, I don't consent to that, and sort of I hadn't sort of given you my consent or waived my rights for that. Even though they've got a buyout, they still were not able to use that content. So it's not an easy topic, but it's hopefully just gives you that sort of idea. And so for the most part, if you're saying this is what we want to commission, we want to use it for X, Y, and Z, and you're still within that sort of so-called lane of future use, the archive material, if it's old, you're going to reuse it in the same vein. It's going to perhaps be used in another film, but in the same sort of contextual setting. You're probably okay with moral rights not worrying. But again, to be on the safe side, you should always look to have people assign and waive their moral rights. They don't assign them, they effectively waive their rights.
Yeah, and it's interesting as well. I think we've spoken a lot about trying to make sure that those agreements are as clear and transparent and fair as possible. And I think, yeah, we're sort of getting into territory where your agreement, you should be very, very clear in your agreement what it is that you're seeking to use something for. You know, you would hope that the contract that you're putting together, even if you're not asking someone to waive their moral rights, you should be clear in terms of what you are using it for. So hopefully there isn't going to be that kind of fallout where someone says, actually, this isn't what I thought I was agreeing to. This isn't what I thought this was being used for as well. Yeah, that's fantastic. Alex, Lottie, I don't know if either of you want to add anything to that, or if you've had any experience with this.
No, I think Jamie covered a lot of things that I was going to say, especially regarding the different ways different territories treat moral rights, which can become very difficult as soon as you're working on anything international, or especially you think of music where, you know, you can be a UK production and everyone working on it is from the UK or resident here. And then you're using music from a different part of the world and they have a different conception of that. So that can become tricky. And especially when it comes to like objection to derogatory treatment and how the music could be used. I know that I've personally been sort of strong-armed by certain productions to sort of withhold a bit of information of how music is used in some sort of in certain scenes, which I've sometimes not been comfortable with. And I've always felt that sometimes an artist might see that and they see their music used in a way they've been misled how the music was used, and they might get angry. They never have in anything I've worked on yet, but it's always something I've been aware of. And I guess it always goes back to this thing as how much risk do you want to take? Do you want to just lie to someone about how you're going to use their music and hope they are not angry in the future? You know, it's like, it's up to you. I personally wouldn't, but some people are very happy to do so. So
the forgiveness.
Can I just add something to that? Because I think Alex is absolutely right that people don't forget. So if you shaft someone, essentially, they will remember that. And the next time you want something from them, guess what? Then so I think again, it's your moral rights as well. You know, it's your moral standards and your standards. You know, and if you are. It's the sort of the sheep mentality, you know, if just because something can be downloaded from YouTube and someone else has said, yeah, it's fine, you can do that, don't believe that. You know, listen to your own moral compass and kind of go, actually, if I were that person, is that the right thing to do? And I do have incredibly high standards where that is concerned, and I you know, context and usage is all. It really is, and it's just being aware that just because someone says it's okay, just always question it and always
Yeah. And again, we're coming back to transparency. We're coming back, you know, all of these sort of things, really being honest about what something's being used for as well. I mean, again, I'm going to hope that most people in attendance here aren't seeking to kind of make use of things in the kind of negative ways in which we've talked about here as well. But yeah, it may sometimes come up if you're trying to use a musical theme in order to introduce a negative character, or if you're trying to use something in a particular way that might reflect badly. Then yeah, it's worth being aware of those things. Yeah, fantastic.
Yeah, as I, for instance, think I've worked on many comedies where there's been a joke about the song playing in the background or the artist and their music, and then I've had to go to the record label and the publisher and say, we would like to have your song playing in the background, and they expressly tell me not to mention anything else. And I'm just sat there thinking, if they actually watch this and you're making fun of them or you're making fun of their song, they're gonna, it's just how. Yeah, it's up to you really sometimes.
Yeah, it's interesting, isn't it? It's funny, I think we've spoken to a lot of organizations who are looking to, particularly if you're looking to use things digitally and you don't have a big budget, and we'll come on to that in a moment as well. This idea of, you know, please don't rely on third-party material in order to establish characterization. Do you know what I mean? Don't say, well, we need to introduce this character by having them walk onto this particular type of song or this particular, you know, it's one of those things where you're kind of leaning into other people's material in order to do a lot of your artistic heavy lifting. And again, you may not get permission to get that piece. So really don't lean into it. Don't build an entire character around their fandom of Katy Perry or something like that. Otherwise you may find it all falls apart. Fantastic. Well, look, I'm going to suggest we do take a screen break here. It's 11:49 according to my laptop. So what I'm going to suggest we do is come back at 11:54. We'll just take 5 minutes to go away, have a blink, grab a cup of tea or whatever, and then we'll come back and continue on. We're going to talk through, we've got some more questions here about specific types of licenses too, and some other questions that you've sent in. Fantastic. Thank you. See you all in 5 minutes. up again now. As always, if you are rushing back to your screen with a mug of something hot, please don't scold yourself or start slowly. We've got some fantastic questions here. Thank you so much. Thank you. We've had some great questions I can see as well, which we'll start to go through. I'm going to jumble up the order a little bit, but we will try and get to everyone, and do keep adding those in as well. I suppose it would be worth kind of talking about types of license and types of right, because we've had a couple of people asking here about PRS licenses as well, which I know can sometimes be a little bit convoluted. So we've had a question from Helena, who's already said that you're looking to release some music which was composed by someone else, a contemporary composer, so presumably someone who still has the copyright of their work as well, and you're looking to do a version of this which you're going to release as an album, and then you're applying for a PRS AP2 license prior to recording the album. Do you need additional permissions to record and release this work on the harp from the publisher / composer, and what's the best practice in this regard? Someone else has asked about PRS licenses as well, but Alex, I wonder if I could come to you first of all, because it feels like we're getting into that difference between the kind of publishing rights and the mechanical rights first of all, which I think is probably worth flagging just in case people aren't aware of it, in terms of the sort of the mechanical recording and then whoever wrote the work originally as well. Can I ask you just to differentiate between those two things first of all?
Yeah, I guess the first thing is that there's nothing to stop anyone from releasing a cover of a song that's already been released. So whether that can be anything, whether it's like the biggest song, you know, like an Ed Sheeran, Taylor Swift kind of level song, or some unknown composer. If it's been released, then and you state that it's a cover, then go for it. You know, they will have the publishing rights, and for anything, you know, whether it's on Spotify, whether it's like sold physically, you go through a PRS, etc. But there's nothing stopping anyone from doing that. So yeah, I guess yeah, you can do that. What was the second part of the question? I guess there's like the ability to do it, which you can.
Yeah, and then I suppose when distributing it. So if I say, okay, we're going to include, and someone else has asked this as well, if you have, imagine you're doing a musical, you have someone singing a song a cappella, do you need to still ask permission? And I suppose additionally, if you're then going to put something out online, so if I'm going to stream something on YouTube or something like that, that's a show that's got me performing songs by other people, do those rights need to be secured? And I suppose further on from that, how does that affect my ability to monetize it? If I want to charge people to come to an online concert, is that affected in any way?
So via the space, I actually spoke with some, I think Northampton, don't know why I'm telling you about, just anyway, our arts company based in the UK about this exact question recently. And I guess under public performance, you know, you can sing anything, you can play anything in your whatever production you're doing. It then becomes very difficult when you're going to record that and put it online and all the different ways that it comes. And that's where all the problems arise. So with this company, I think they've got some sort of pantomime, and they have everything. There's a Queen song, Olivia Rodrigo, Robbie Williams, like some of the biggest artists of all time. And I just sort of turned to him and was like, you're never going to do that for the tiny rights that they want. So
and what was the deciding factor in that? If people can do covers of things, was it because they wanted to use the original recordings or the original bed tracks, or was it because they were releasing it as a recording or a capture? What was the
so what's that? Sorry, Rob. I think we've gotten two things. I guess firstly, anyone can cover anything and release it, and that's, as I understand it, been sort of set from sort of some historical rule in an early 20th century America. And anyone can perform songs, and there's nothing going to stop you, you know. And if you're out tonight and you're a singer and you want to sing Beyonce, nobody can stop you, as long as that place has their PRS licenses and things like that. So yeah, anyone can cover anything that's already been released. Anyone can perform a song in a venue, but it becomes tricky when you want to record that and then put that elsewhere, say on the internet. put it on YouTube, put it on your website if it's behind a paywall and all sorts of things like that. And then you need to secure the rights. If it's your performers singing an a cappella version of the song, then you would only secure the publishing rights. If the recording plays at the same time, you would secure both the publishing and the recording rights. So, yeah. And that's a big problem, I guess, every small theatre across the UK is having right now, especially post-COVID, when it's very different to how they've operated just forever, right? So
yeah, absolutely. And I suppose for a lot of theatres, they've had a PRS license which covers in the venue. So it covers everything happening on stage. It also covers screens in the foyer for latecomers, that sort of thing. It will cover, people singing carol concerts at Christmas outside the Panto and things like that. But then as soon as you start live streaming, as soon as you start putting things online, PRS doesn't necessarily cover that. I mean, I know I can see, Helena, the question you've asked, you've talked specifically about an AP2 license, which would cover mechanical distribution on CDs or DVDs or whatever it might happen to be. As soon as things are online, that becomes different. Now, I know you've not specifically asked about online, so it might be you're not planning to do that, but it is worth flagging there is that limitation of PRS. We've also had a question, or I suppose an observation as well, from Joe, who said you're looking at the music that you've been using on podcasts and materials that you're putting on SoundCloud, which SoundCloud themselves do not cover, and unfortunately a PRS license is unlikely to as well. Your best bet in that kind of instance is probably looking at copyright free music sites, free music archive.org and things like that, where there are people.
Rob, can I jump in there? Sorry.
Please, yeah.
I would say to whoever that person is, I believe Spotify have it covered. I'm not 100% sure on that, but I believe Spotify do. And any music that's on Spotify and it's in your podcast, I'm not 100% because podcast's not my world, but I'm pretty sure I've read that. So check out Spotify.
Because I suppose they already have a license to host the music on that platform to begin with. So as long as it's on there, maybe that is okay. But yeah, do have a look. As I say, it's not our area of expertise, but do have a look. That's fantastic. Does anyone else want to add anything before we move on, Jamie or Lottie?
No.
Just Alex, just that point about Spotify though, that still doesn't give you the right to just download anything from Spotify and use it in any way you want. I mean, it's that whole thing, isn't it? Again, of what material on Spotify is cleared and clearable for, and
yeah. I guess like when it comes to a podcast and you upload a podcast to Spotify and there's a little snippet of a song in there, then you can do it. I guess Spotify will have very set rules of what they constitute for use within their podcast agreement. Again, it's not really my world at all. I'm not in the world of pod. It's something I'm vaguely aware of. And I'm pretty sure, SoundCloud don't have a huge amount of licenses compared to Spotify. You can't just go on SoundCloud and listen to Taylor Swift, whereas you can on Spotify. But yeah, it's a different thing. So yeah.
I think it's worth moving from here onto YouTube as well, because we've had some questions about them as a platform and specifically public domain as well. So we've had a few people saying things. First of all, if let's have a quick look. People are saying I'm seeing covers of copyrighted music on Instagram and YouTube, for example, sometimes viral, famous music with millions of views. Am I right in thinking even these short covers constitute a copyright breach? From what you're saying, Alex, it sounds like they are, but they're maybe not worth the labels going after. Is that right? Or are they okay?
Well, no, it's fine. If something's been released and you cover it and it's a genuine cover and you don't change it, I guess the concept of how much you change something is quite open to interpretation. But as long as you're not changing the lyrics and things, then great. I guess then when it goes from a cover into interpolation is a different thing entirely. So you would then need to seek permission.
I see. That's fantastic. Thank you. And a few people have asked as well questions about material found online. So someone has said if they take a still of something being broadcast on YouTube or TV, do they own the copyright to that still? I'm going to imagine the answer to that is no.
No.
And I can see you shake their head.
And I think this is the big problem, is that once something's recorded, it can seep out anywhere. And I've had so many of my really quite complicated dance documentaries and performance, particularly dance. We all know how difficult it is to do dance. Just uploaded to YouTube.
Yeah.
You know, an hour and a half documentary and a 2-hour performance ballet on YouTube. Someone else has just uploaded it. We have no control over that because people can download anything and upload anything. So it's the whole thing of the lawyers then. Every time it goes up, the lawyers are asking them to take it down. It gets taken down, and then 2 months later, it goes back up again. So again, it's the whole thing of that we have no control over who uploads what where. All we can do is the thing that we create in the first place. If we know that we have cleared everything for usage, if it does seep out and go up somewhere, at least you know you've done your job and everything inside that. If you then either take a still of it, take a screenshot of it, no, you absolutely do not. You have the rights in your photograph that you've taken. You can put that on your wall. You can print that off on your wall, and you can have that and go, oh, that's a lovely picture. But you absolutely cannot use it in any platform at all.
Which brings us on to a couple of connected questions as well, because I think a lot of people do believe that if something's on YouTube, then it's public domain. And of course, it isn't, because I could take anything I wanted to and put it on YouTube. It doesn't mean I had permission to put it up there in the first place. So it's really worth being aware of that. I mean, they clamp down a great deal on music because it's something that they can obviously identify very easily, and the music industry is enormous and will stop them doing it. The same with film as well. But it's really worth being aware. An awful lot of stuff is put up there without permissions in the first place. The person that put it up there didn't have permission. YouTube's not able to grant you that permission.
You've got obviously there's different aspects as well. I mean, YouTube is a commercial platform, so it has its own set of terms effectively. So any content on there belongs to the creators and effectively YouTube to control. You can't just, so that means TikTok can't just go on there and pull all the content, even though people might think that's amazing, I'd love it to be on TikTok. They can't just go on there and just sort of data mine all the content. So at a commercial level, you have the fact that the terms restrict you, and that's where there's been a lot of things around influencers and the content and people scraping content from Instagram and trying to use it as well. And there's a whole sort of raft around there. But then obviously there's the underlying content creator point as well. That content belong at the first instance, whoever's uploading it has the rights in the upload. But then the upload itself could be infringing rights underneath there, as Charlotte said, in terms of what is it they're uploading. But it's interesting because if you look on there, this is where it shows it's a completely grey area, and this is the whole point of a judgment call, a mixture call. I saw some questions about age of content, but a good example is video game footage. You'll see a lot of streamers on there, influencers playing video games, streaming content. Now, that content from the game, does that infringe? Technically, it does. It infringes the terms of use of the game. But all of the game studios, they have these terms, but they turn a blind eye because it's part of their marketing. They want that content to be talked about, to be streamed, to be looked at. They just have it in their back pocket that if it's being used in a sort of fashion they don't like, perhaps it's been used on an ultra-violent channel or something like that, and it's been used in an aggressive sort of someone's channel using it as in an aggressive way, and saying, look at this, it's great, I play these violent games and then I do this. That's where they'll take action. But for the majority, they'll just turn a blind eye to it being used because it's great for them. This is the balancing part of it as well. But it's not to say just assume that because you're using something, a clip or a thing, and saying, well, it's great because it's getting it out there, you're effectively taking the control of that content away from the person who controls it or created it.
Yes.
And they may not want that. So it's a balance, and this is the thing. There isn't a necessarily right or wrong answer in a lot of this. It depends, and I know that's a very vague answer, but it does depend on the circumstance scenario.
Yeah.
Cool. And sorry, Rob.
No, go for it. Go for it.
I was going to say, to continue Jamie's point, discussing like video games and I guess Twitch for being a streaming platform that you're referring to. I know a lot of computer games right now have a special Twitch version of it because they haven't licensed their music, which is in the game, for Twitch. They've only licensed music to be in the computer game, not to be live streamed on the internet. So there's certain games where I'm going to be on Twitch and it removes the music because what Jamie is saying, the computer game company are happy to have their product out there basically being advertised, but they don't have the rights to everything, so they remove that themselves. And I guess the thing running throughout all of this is there's so many rights. It's not just one work. It can be rights within rights within rights. And yeah, there's a lot to consider, and who owns what. And they can give you something, but they can't give you everything. So you need to speak to other people, and it's very complicated very quickly.
Absolutely. I would encourage everyone who wasn't with us for the first part of this webinar back in June to go back and look at Alex's demonstration of how convoluted can get when you have songs sampling covers of samples of all sorts of things. It's fantastic. It's really fantastic. We've had someone ask about this actually. Someone saying that a visual artist we're working on a website with wants to use an old photo from around the 1950s to illustrate some information. It's copied from a Wikipedia. We don't know the creator, and that information doesn't seem to be easily available. Could we use it on a website / social media? And what's the best thing to do when you can't find the origins of content that you might want to use? I suppose there's two parts to this. So first of all, the material that's on Wikipedia does normally come with credits. It does normally come with information as to where it's come from as part of the terms of upload. So that material should be on there if you can find the original pages come from. But additionally, if you can't find the owner of something that you want to use, again, I suppose it's coming down to risk for you if you're going to use it, knowing that that person might find out you're using it and suddenly turn up. And once you have established a paper trail of you asking for permission to use something, they can come back and say, well, you did know that you needed to get permission and you didn't, which can be difficult. Has anyone got anything they want to kind of add to that? Otherwise, there's another example.
I mean, it's a very old photo, obviously, but copyright could still exist. It can exist in a number of years after an individual's sort of death. But I guess there's a multi-layered aspect to it as well. And by that, I mean, well, what's the photograph of? Is it something that itself is subject to copyright underlying? So back to that point of, if you just take a picture, and for example, it could be a building, for example, that sort of there's copyright still existing, although it's probably likely to have expired potentially. But there is copyright in the underlying material constituting the photo. Now, let's say the photos are just of a generic object or a nondescript property or something. It then is the photographer, and I guess it comes to this risk. If, say, you were taking that photo and you were going to put it on a t-shirt and you were going to mass produce that for Primark as a supplier, that's obviously on a very different scale to if you're just going to put it on your website for some reason as a small sort of piece. And it's that balance of, well, where is the commercial risk here? In a way, you're not going to go and necessarily run down all avenues. You might take a view and say, well, we are going to put it up. There's a slight risk, but if someone gets in touch, we'll take it down. What are we using it? What are you using it for? What is it? If it's generating significant revenues for you, and it's a key part of your commercial business, then there's a much higher risk than if it's just there for an interesting backdrop to a website, for example. But I'd just add on that, on photographs in particular, places like Getty Images, others, if you don't license things properly, you take something from their site or something, they will find you eventually. And it sounds like very sort of dramatic, but we've had a client who came. She ran a very, very small baby clothing website. It was actually, she shut it down a year ago, but it was still archived out there. She used an image, and there was a company who represented one of these rights holders, got in touch, said, you owe us £500. You put it on the website, you didn't get consent, and you're in this difficult avenue. Do you argue that? Do you pay it? Do you pay for advice? You're in an amount, they pitch this at an amount that is just on the fringe of being, well, it's not too much, but then it's not worth the hassle. This cage it in very legal sort of terms, these letters, but this is the point. If you're putting something out there are trawlers out there, there are bots that trawl the website looking for infringing content, be it music, images, and they just deploy these, and you run that risk, really. And it's a risk approach. Like anything, you cross the road, you run the risk if you're walking traffic, but yeah, you've just got to balance that out, really.
Yeah, and not to scare people, but as further layers that I can add to that, and I see this quite often in film and TV, say you might have the actor, baby photos of the actor, and you try to use it in the show or something, and they have two key problems. The first one is they don't, they get the image rights of the actor, and that can be totally fine. The second one is who took the photo. Maybe it's a photo of the actor when they're 5 years old, and people can't quite remember. Is it their dad? Is it their auntie? And all different things that come from there. Who has the copyright in that? And then the further thing, which can actually add extra complications, would be trademark. And say like the actor's wearing like a big Nike jumper, and there's a big Nike tick on them, and there's Nike get involved in that, and it gets very tough very, very quickly. So it's kind of funny, this entire 90 minutes is like we just keep into it. It's like, well, there's other things you need to worry about.
Absolutely. It's an interesting one as well, and it's worth clarifying some things we've already said, because again, we're talking here about the photographer, and this ties in with two questions we've asked. So I know Christine before, who had asked the original question about taking stills from a live stream or a piece of video, and we said you wouldn't own that copyright. I know, I can see that you've said, I thought the photographer always owned a copyright, but I'd say if you're taking stills from something that someone has already created, they created that, you're simply duplicating it, and so that wouldn't apply. Someone else has asked the question as well: if a visual artist sells their unique artwork to someone through a shop or gallery, etc., can the purchaser do anything that they want to with the artwork? And yeah, immediate shake of the heads here. I'll put in the chat as well. There was a story last year from an artist called Hayley Bateman, who a Belgian art centre had reached out asking if they could use one of her pieces as the poster for their new exhibition, and she said no. They then bought a copy of her artwork as a print through her website, scanned it, and started using it on the material, and it got, and rightly so, there was an enormous backlash against that art centre. Hayley herself didn't have the resource in order to pursue them legally, but it was a huge story. They obviously shouldn't have been doing it, and the entire community did rally round. I'll link to that in the chat because it is worth having a little look at as well.
But just on that, Rob, I mean, I don't even want to mention the word because we open up a whole area, but NFTs, for example, this sort of, the example you've given is great, because that's where there's an existing sort of photographer or art. And again, I had a query the other day. Someone had a book of images they'd taken, and someone just wanted to use those for something. She said no. I just urge a bit of caution there. If you are a gallery and you've commissioned perhaps a digital piece of artwork specifically for something, again, your rights could be overridden in the terms. And so this is very important for artists. If you're being asked to sign things on the other side, I mean, we're talking about people commissioning content, but if you're on the other side being asked to create content for something, don't just blindly sign things, because ultimately you could be giving away a lot of your rights. And it's becoming increasingly important where digital artwork, content, images, video are being used for NFTs, because obviously you've got this tug of war between NFTs wanting all rights so that you can sell it on in perpetuity, people can do things, versus artists keeping control, and you have these digital forms of contracts. So again, I guess an overriding point is, are you being asked to sign something? What do the terms say? Even if they're set out in email and you're not necessarily being asked to sign something, just be conscious of what it is that they're asking you to commit to and to agree to. Because again, you could find that you perhaps have given away rights when you didn't mean to.
Yeah, that's fantastic. Thank you so much. we've got a couple more questions before we start to wrap up as well. So someone has said, I love this question. This is hugely specific. We commission furniture from our own designs. Do we own the copyright, or does the cabinet maker have the rights? So if you've designed something and had something commissioned from that, who owns that copyright? I mean, I suppose that would be the same if you're having someone build a set for you, or if you're having someone, you know, create a costume or something like that, a costume maker. So this must come up a lot. I mean, would anyone like to jump on that? Has anyone got any?
So, I mean, all I would say is that you are commissioning it. You are hiring an artist or furniture maker to make it for you. Therefore, you will at some point be creating a contract with that person for their work, rolling the rights at the same time. So with that, yes, essentially they are creating a creative piece for you. There may be residual rights to you using it. Again, it's how are you going to use it? What are you going to use it for? Where are you going to, where are they eventually is that performance going to happen, or are you filming it and then putting it on a platform? So it's at contract stage with the person that you commission to create the piece. The rights need to be rolled in at that point. Jamie, do you agree? And I think it's that thing again of, you know, the word buyout to me at that point is you're commissioning someone to make a prop essentially.
Yeah,
I would not expect that to attract residuals. I would expect that to be an all rights buyout for creating and use of the piece.
And if, I guess on that point on the furniture, if you are literally saying, here's the design, just build me this, again, there's not really likely to be any residual rights left with the maker, because they're not adding anything to it. If you were to give them something and say, I'd like to do something here, but not sure really, can you come up with something unique? That's when they're coming up with uniqueness, and that's a really interesting area of, then if you then go to exploit that, what have you paid for? Have you just paid for that one-off piece to be created and sold, or does it have the reproduction rights with it? And again, it's a real sort of, you've got to be clear. And I think, but if it's your own design, simply replicate this, build this for me, then you can probably be on fairly safe ground that you own it. But again, nothing to stop you. A simple 2-line email or just a short letter, short agreement saying, I'm commissioning you to do this, I'm paying you that, you have no rights. To clarify, it's sort of, we own everything that's been sort of created in layman terms.
Yeah,
but even if you are commissioning someone to design those pieces, I mean, again, it's one of those is that I would always try and get that on a buyout, the actual design of it in the first place.
Yeah, oh, definitely, yeah. If you're commissioning something to design something, absolutely, and it goes to scale as well. I mean, it can be a prop is unlikely to be an issue because but then it goes to where, well, how is the prop being used? Is it a central piece? And we've had issues where someone wanted to use a sculpture, for example, in a short film. And they reached out to the sculptor and they said no. So what did they do? They just recreated the sculpture. They got someone else to make it and feature it, and then lo and behold, the claim pops up. And not only have they used something without permission, they've also and we touched on this last time, they've also reached out and put these artists on notice. So they're just sat there waiting and thinking, well, when's this going to come out? I've got the letter ready. As soon as it comes out, there's the letter in there and saying, well, by the way, you expressly knew we had the rights, you still went ahead. And that's when you're into even trickier sort of position, because you've expressly gone again, not only breached copyright, but you've deliberately and intently sort of gone and done that as well. So it's just a word of caution there.
Yeah, that's fantastic.
Cool.
Thank you, Jamie.
And I guess, sorry.
Go on, Alex. Go on.
Okay, well, I guess continuing this sort of idea is it works across all sorts of things. So say in music and you write some sort of melody, but you can't play a violin, so you hire a violinist to record it, to play it for you. It's the same sort of concept as like getting someone to make for furniture you've designed or whatever, isn't it? You know, it's all covered in this work for hire contract, but you have to be very set in music, quite often they like record the sessions now, just in case the musician then says, I actually embellished it and made it better or something like that. And or it goes into that grey area, which, there have been lots of legal cases in music where that comes up. Like, like Procol Harum, I think they had that exact sort of thing with the
Lauren
harp
Hill, I
that
think,
begins in that song.
yeah.
So I guess, it is always one of those, like, just cover your own back. In music now, they always have recording of sessions and things like that. So there's no dispute to me that I definitely did this, then you copied, because,
fair enough. That's fantastic.
Is it worth getting into parody, or is that just a whole other world that we'd need?
I think that's probably a whole other, I think that's a half-hour session all in itself.
Let's do that next time.
It's quite a worry. And we're starting to run out of time. There are a couple of things I wanted to touch upon, and I think what we'll probably do is signpost rather than discuss, just because we're running out of time. So we had a question right at the beginning, understandably, from the Story Museum team asking about effective models for equity split between creatives and creative organisations for commercial and non-commercial digital content and licenses. I think for that one, I'm going to direct you towards the first half of this webinar. We'll pop the YouTube link. We did talk about that in quite a lot of detail. Again, talking about and defining elements like favoured nation agreements and so forth. And again, some of the differences. So for example, there you're talking about an equity split for commercial and non-commercial digital content. You need to be aware that there potentially isn't any equity if it's a non-commercial piece being produced, kind of where's that money coming from and so forth. But I would say do have a look at the first half of this webinar. Megan, I can see from National Youth Arts Wales as well, has said, have equity/UK Theatre/ITC negotiated standard rates/percentages for inclusion in various theatre creative freelance contracts in anticipation of theatre performances being streamed through paywalls or not. I think they have started to display some individual rates for particular types of role. To be perfectly honest, I've often found those to be quite low. I've found those to be underrepresentative of what people are actually charging or expecting. I would always say use them as a starting point, but be prepared to come up, and it will come down to the negotiation with the individual team members that you're choosing to bring onto a project. Do go into those. And again, it shouldn't feel like a battle. It shouldn't feel like a fight. A really good agreement should make everyone feel relieved, everyone feel relaxed, everyone absolutely understand what's being expected of them and what's being done. I'm going to ask one final question because I'm conscious I may have overcomplicated Alex's answer to this question before. Someone has said, simply to clarify, Alex, if I make a short film and have someone singing a cover of a song, do I or don't I need permission?
You do, from who wrote the song.
Okay, that's fantastic.
So you would find that on the PRS for music database, and you'd go to seek whoever owns the publishing rights, and then on the off chance it's public domain, then then you don't. If it's singing Bar Bar Black Sheep or something like that.
That's fantastic. Thank you very much. And yeah, apologies to Joe that I think I stumbled over some of Alex's answer to that before, so I hope that clarifies. We are going to pop some links into the chat now because we are coming to a close. I can see that my colleagues are already popping in links to the first half of this webinar. We've also got details of the Spaces Rights Toolkit as well, which hopefully will help a lot of people as well. There are elements in there, as we've said, about kind of contracting and different things that you need to consider. I can see that a few people have been posting links as well. So again, thanks to the Story Museum, who have posted links to the Orphan Work Service, which is a nice way of finding the origins of particular types of material that you may want to be using. So do check those out as well. Crucially, we're also going to pop a link to a survey in the chat as well. Please do take a moment. I know this is the kind of unfun bit at the end of all webinars, is being asked for your feedback. It is a mercifully short survey, and I should stress the results of these surveys directly 100% absolutely influence the materials that we continue to put on. So the fact that we're here today is in direct response to the feedback that we got from the last one of these webinars. It lets us know how useful these are. It lets us know how much appetite there is for more. It lets us know what we need to be covering within these sessions, because we do try and make them as bespoke as possible in order to help you with wherever your challenges may be, no matter how you define digital and art and audiences and so on. So I would say, please, please, please do take a moment to fill that in. It really does make a huge, huge difference. Finally, I'm going to say a huge thanks to all of our speakers, to Jamie, to Alex, to Lottie, and a huge thanks to all of you who have contributed today with questions, to Jen for the captioning. I know this must have been a challenging one as the conversation was all over the place. So huge thanks to you all. And yeah, we will see you hopefully at the next one of these events. We'll leave the chat open. We'll leave the Zoom thing open in case anyone wants to grab any notes. Please do fill in that survey and grab any of those links. Otherwise, we'll turn off cameras from this end and we'll see you at the next event. All right. Thank you, everyone. Take care. Bye.
Everyone. Bye.